The Supreme Court term starts the first Monday of October, and we are going to talk a lot about the Supreme Court's upcoming term in a couple different articles. So this article is dealing with the Supreme Court's business docket, looking at upcoming cases that have potential impact towards businesses in the upcoming terms. Things to expect as the Supreme Court begins its new session on Monday. Let's get started with this. The Supreme Court in recent years has become increasingly skeptical of the power of administrative agencies. Not skeptical enough, in my view. We all know how I feel about Chevron versus NRDC, so we don't have to go into that yet again. In the last term, it restricted the EPA's ability to tackle climate change because of the statute, the way it was written, and OSHA's ability to limit the spread of coronavirus, again, because of the statute and the way it was written. For many logical reasons. On November 7th, the court will hear a pair of arguments that could make it easier to challenge the constitutionality of two other agencies, the FTC and the Securities Exchange Commission. The cases are both about timing, asking the justices to decide how long people and businesses must litigate with the agencies that seek to regulate their conduct before they can go to federal court. So this is all dealing with when does a decision become final, basically, because at least in the federal system, you have to exhaust your administrative remedies before you can go to court. And so like one of the questions might be, okay, when does that happen? When have you exhausted your administrative remedies? So that's the question in these cases. The first case, Axon Enterprise versus FTC, concerns a firm that makes body cameras for law enforcement. Yeah, that's probably the most popular body cam manufacturer, Axon Enterprises. You see their work all the time. And it was investigated by the FTC as part of a merger review, which is fairly typical. Rather than waiting for the conclusion of the proceedings before the agency, the company tried suing the federal court, arguing the agency's structures are unconstitutional and it does not have the authority to review the merger. So is the agency set up in a legally appropriate way? And we've seen this be an issue before, for example, for the National Consumer Finance Bureau, I believe it was called, which had problems with its structure because Congress set it up improperly. So does FTC have similar problems? I don't know, but that's one of the things they'd like to challenge. A divided three-circuit panel of the U.S. Court of Appeals for the Ninth Circuit said Axion's argument had some potential force. So although it's been rejected by the Court of Appeals, they think maybe there's something here. And so the Supreme Court might want to do something with it. The second case, Securities and Exchange Commission versus Cochran, concerns an accountant accused of misconduct by the SEC and involves a similar issue. The accountant, Michelle Cochran, sought to challenge the structure in federal court before the administrative procedures were completed. The Fifth Circuit agreed she should be able to bring the claims, creating the sort of conflict between federal appeal courts that often prompts Supreme Court review. So yes, one of the issues here is when does your case become final? And even more appropriately, is the agency structure set up appropriately? Is it set up as an administrative agency properly with the appropriate structure? And we've seen this be an issue before. And are the people, for example, appointed by people who have legal authority to appoint? Are they created properly? So these issues have been dealt with before and should be dealt with again. So yeah, that's basically what's going on there. On November the 8th, the justices will consider whether states can require corporations to agree to be sued in the state's court as a condition of doing business in the state. So right up now, at least under the federal law, if you want to sue a corporation, you can for sure sue them the place where they're legally incorporated. And you can for sure sue them the place where their principal place of business is, which is usually defined as the place where its C-level officers are, like its CEO, things like that. And obviously, depending on your corporate structure, that can get confusing, but those are the two places, right? Where are you legally incorporated, and where is your principal place of business? So some states want to be able to have the businesses sued in their state no matter what. And it's like, can states impose that condition? In order to get a business license, you must consent to being sued in our court. Okay, so the case, Mallory versus Norfolk Southern Railway, concerns Robert Malway, a Virginia man who says he developed cancer from exposure to toxic chemicals while working in Virginia and Ohio for the Norfolk Southern Railway Company, which is based and incorporated in Virginia. So you can sue him in Virginia. That would be fine. The question in this case is whether he can sue in a third state, Pennsylvania. Now, why he'd want to, is a whole bunch of issues, like more favorable courts, better statutes, more convenience, a whole bunch of reasons. So the Supreme Court has long said that corporations may be sued where they are incorporated and where their headquarters are. That is the law as it exists now. And they may be sued in a particular claim if the case is related to the context within the state. So yes, you might be able to sue a corporation in other states if what you're suing them over occurred within the state. Mr. Mallory over here requires on none of these specific bases for jurisdiction. So it's not you're incorporated here. It's not that your C-level office suite is here. It's not that the product that injured me, for example, was sold here, right? None of those things. Rather, he points to a Pennsylvania law that requires companies that do businesses in the state to consent to being sued there. This railroad has said the law is unconstitutional. It might be. It might be a problem with Dormant Commerce Clause, for example. An illegal restraint on trade, for example. And saying, well, that you have to consent to jurisdiction, which is undermining perhaps the federal court jurisprudence on stuff. In a brief supporting the railroad, the Biden administration has said the Pennsylvania law subverts interstate federalism by reaching beyond Pennsylvania's borders and allowing state courts to hear cases in which Pennsylvania has no legitimate interest. So yeah, basically what they're saying basically is this is undermining international shoe, which every law student knows. It's an incredibly famous case in jurisprudence, in civil procedure that says, sufficient minimum contacts. And the problem is here, although they're doing business in the state, it's not as a result of doing business in the state that the injury occurred, right? It's not that the injury occurred in Pennsylvania or they did something in Pennsylvania. It's just because they're generally doing business in Pennsylvania that I can sue them in Pennsylvania. It's like that kind of undermines the international shoe. So I would expect this to be a problem. I would expect this to not pass muster. On October the 11th, the court will hear National Park Producers Council versus Ross, a challenge to a California law that seeks to reduce cruelty to animals by requiring that pork sold in the state come from breeding pigs housed in spaces that allow them to move freely. The law forbids the sale of most pork in California unless the pig it comes from was born to a pig that was housed within a 24 square foot space. But most pigs are kept within a much smaller enclosure. So again, this is potentially a Dormant Commerce Clause problem, right? It's a state imposing a regulation that is perhaps inhibiting the free trade of goods. And so this is a potential problem. These pens, the group challenging the California law wrote in a Supreme Court brief, provide around 14 square feet of space, and for hygiene, safety, and animal welfare and husbandry reasons, do not allow the pig to turn around. Okay, so that is the pigs, that's where they are normally kept, and so they're like, okay, this is a pretty big restriction. Given the size of California's market, the pork producers say the state is effectively seeking to regulate business outside its territory. So this is a common issue that pops up a lot with California in particular. Because California is such a big state with so many people, it can have outsized influence. So, and because of that, it can be a burden on interstate commerce. So you do see a lot of these challenges coming from California as a result, not for at least the reasons that California seems to have no problem trying to impose on other states with its will. So yeah, it's not a surprise at all. It comes from California. A unanimous 3-judge panel of the United States Court of Appeals for the Ninth Circuit rejected the argument that the law's out-of-state effects make it invalid. State laws that regulate only conduct in the state, including the sales of products in the state, do not have impermissible extraterritorial effects. A little bit, maybe, but the case law is not quite that black and white. Just because it regulates only conduct within the state does not necessarily mean it doesn't violate Dormant Commerce Clause, right? Because goods are traveling through the state, for example. So if they're trying to burden commerce that's moving through the state or the instrumentalities thereof, or basically, in other words, imposing a tax or levy in a fact or word, then that poses some problems. So there are some issues there. I don't know how that case will resolve, to be honest, but it should be an interesting one to watch. 2 cases of social controversy that have gotten a lot of attention also has big business implications. In a majority challenge to affirmative action programs, the court may strike down race-based admissions in colleges. We'll discuss that more in a different article. But whatever happens there might have spill-on effect to other cases. The pipeline of credentialed minority candidates might tighten, defenders of the programs have argued, and depending on the logic of the ruling, employer diversity efforts could also be challenged under federal law prohibiting workplace discrimination. So yes, there are federal laws that prohibit discrimination on the basis of race in employment as well as education. And so, yes, it might be the case that if the educational institutions can't discriminate on the basis of race by giving out preferred positions, for example, on the basis of race, or providing benefits on the basis of race, it would logically hold that businesses can't either. They can't also discriminate on race, so that would be a problem. A brief supporting the universities filed by scores of companies, including Apple, General Motors, Google, Meta, which is Facebook, and Starbucks, said they rely on leading colleges and universities to train diverse leaders, and that radical and ethnic diversity enhance business performance. So they like the discrimination on the basis of race and will let it continue, giving certain races certain preferences in the formalized way. Okay. Also, an extremely interesting case, it's Masterpiece Cake Shop all over again, although even more cleanly on the issue of free speech by businesses. The court is considering a Colorado web designer case. The Colorado web designer is in the business of producing websites. That's what they do. They were approached in order to create a website that would celebrate same-sex marriages, and they said, no, I don't want to create that speech. They were sued on the basis of that, saying, oh, you're discriminating against us on the basis of our sex or sexual orientation in Colorado, right? And so this is Masterpiece Cake Shop, although it's a little bit more clean because this deals with more pure speech, right? It's not writing on a cake. Now it's creating a website. So it's a purer version of that, which is a cleaner case for the Supreme Court to consider. So the Colorado web designer has said, I'm not creating a website that celebrates same-sex marriages, even though state law requires me not to discriminate on the basis of sexual orientation. So the state law says don't discriminate on the basis of sexual orientation, but it's speech, and so they're saying the First Amendment trumps. As a legal matter, of course, the case concerns free speech, and a ruling in the case might allow other businesses. Now, I think this is almost certainly going to be decided in favor of the web designer. And it'll be really, really interesting to see what the language holds, because it'll be interesting to see like how far from the abstraction of speech the logic goes, right? Or whether they speak to the issue at all, right? So they're going to rule in favor of the web designer. I can't see any other solution. And then the question is, how far do they go beyond that to issues like, for example, Masterpiece Cake, which is more of an abstraction, but still deals with freedom of speech issues. So those are some of the business cases that are happening right now at the Supreme Court this term.